In the 1930s, moving pictures with synchronized sound was still a new and exciting technology. RCA Photophone, the Radio Corporation of America Photophone, was one of the dominant players in this technology. The defendant in this matter, Hope, had agreed to hire some equipment from RCA Photophone. Basically, it was an early theatre setup with a projector, a screen, and all the electrical equipment required to make it run. The contract said that the agreement was for the hire of certain new machinery and equipment, more particularly described in the schedule to the agreement. The schedule then listed out individual bits of equipment that were part of the package, but in the schedule there was no indication that the equipment would be new. There are two ways to look at this. One is to suggest that the term new machinery and equipment meant that both the machinery and the equipment needed to be new. The other is to say that the word new only applied to machinery and not to the other equipment. The court took the latter view, so the equipment didn't need to be new, it just needed to work. The equipment supplied by RCA Photophone was not new, and Hope refused to pay because the used equipment allegedly kept breaking down. RCA Photophone, however, said that nothing in the schedule referred specifically to new equipment. Hope responded by referring to negotiations before the contract, where they said the parties had only ever been discussing the hire of new equipment. In return, RCA pointed to a clause of the contract that said the contract contains the entire understanding of the respective parties with reference to the subject matter hereof, and there is no other understanding, agreement, warranty, or representation, express or implied, in any way binding, extending, defining, or otherwise relating to the equipment. The court found that this statement, which we call an entire contract clause or an entire agreement clause, was conclusive. The parties had signed a provision which said that their entire agreement was to be found inside the contract, and so neither of them could argue that representations made regarding the agreement were in fact terms of the agreement. The use of an entire contract clause remains a standard way for parties to protect their contract by excluding any other words from being regarded as contractual provisions.